I'm excited. I'm excited. And okay, all right. It's Sex Week this week in UT, and I probably should have run this past management, but here goes. Okay, we've got today. We've got Queer History and Cinema at 1:30 McClung Tower. Gender Smackdown at 2:30. Queer Theory 101 at 3:30. And there's a very important lecture in Knoxville this afternoon. Trans sex positivity. Now, I want you to know that that you may have missed some things, and that includes missed "Come One, Come All." We're told on the website to the Sex Week Carnival. Join us to kick off the week and making Mardi Gras on Beale Street look like a Sunday school picnic. We're told that this is a raucous and very, very exciting event at UT, our state-funded, taxpayer-funded university. Now, you missed also on Friday. Of course, Friday's a big day at the university when you have got your classes lined up. You can do a bit of work on a research paper on Saturday and maybe sleep in on Sunday. But there was a cabaret that went for 3.5 hours at Carousel Theater Sex Week Cabaret. So today, just after lunch at McClung Tower, there's Queer History and Cinema, and a couple of professors a little bit down, further down in the afternoon, Queer Theory. Wikipedia says Queer Theory, quote, focuses on mismatches between sex, gender, and desires. And we're going to have a talk from the English department, Dr. Gerard Goin-Vrignaud, French name, and Dr. Liliana Gonzalez, Hispanic name. That will be Queer Theory at 3:30. And we'll hear at 5:30, just around dinner time, the Trans Convo Starter Pack. What's involved in the trans life and experiences. It's a funny and fast-paced participatory hour. Make sure your son or daughter doesn't miss out. And make sure that son or daughter attends this important cultural event. At 7, there's a trans sex positivity, the process of desexualizing trans people. Now, here we have a question about people who have crossed the sex line. It's not a gender line, it's a sex line. They're trying to become the sex that God did not make them to be. And there's one problem they have is that they're being desexualized unfairly by other people. In other words, you and I, we're told, tend to make them sexless people. Just because they're in transition from male to female doesn't mean that we should be so cruel as to deny them a sexual identity, or as they say, a gender identity. You say, well, Dave, what's your problem with using the word gender? Gender is a word that comes out of the use of language. For example, the word gender describes in French male or female nouns. All nouns in French are male or female, and that distinction in the language, of course, can't be eviscerated by the most amazing contortions and gyrations of linguists and academia. They're always going to be there. That's gender, okay, male, female. A sex. Now, you, my listener, you're either of the male sex or the female sex. You don't have a gender, okay? You have a sex. That's just something that the activists in the sexuality area want to change. But the process of desexualizing trans people to make us respectable and non-threatening is nearly complete, we're told. But where does that leave us besides sitting bolt upright and fully dressed with all 4 feet on the floor? An exploration of the soul and sexual norms imposed upon the trans community, what happens to those who break them, why we love to hate them and hate to love them, and what sexual orientation means to someone whose gender is subject of debate. That's Sex Week again today, tomorrow, and a raucous and joyous week through Thursday at UT. There's a history of erotic art with Dr. Aurelia D'Antonio on Tuesday at 2:15, and in the art and architectural building in room 103, and also a lecture on virginity. What does virginity mean historically and today, from the ambiguity and the gendered definition to what prescribed set of sexual behaviors lead to checking the box on losing or keeping your virginity. And guess the people most knowledgeable about this, Planned Parenthood, and a man named Tory Mills, I take it that that's a gentleman, will be discussing what abstinence means and what it looks like from a religious, secular, and of course a medical viewpoint. There's also going to be a talk on reproductive justice, and also CSI might appear a whole lecture on the female time of the month menstruation, and you can learn more about the process that monthly wrecks your uterus, we're told. There's also, I won't tell you everything that's happening because I didn't talk with management about this ahead of time. But there are some wonderful discussions touching even anal sex, which is of course sodomy. But that's a right and not to be ashamed of, right? You shouldn't be ashamed of that. That's just something that we have to accept, even where the female is the aggressor using certain pieces of equipment. The female becomes the moving party in one format of human sexuality celebrated at Sex Week at UT, and making everyone more cultural, more refined, maybe more sexual, maybe more lively, more colorful, no doubt. Now we're talking about something that's really important, and that is a ruling that has come out of Nashville, touching on an issue that we believe would be here a great benefit for life in Chattanooga and Hamilton County, where I, your host, am, and at 92.7 FM and 95.3 FM HD4. We're live on Facebook at Nooga Radio. Do go to Facebook. Just keep the page open if you want, and also live on YouTube. The ruling is kind of a half-baked. It has a kind of a half-baked analysis. But insofar as it goes thoroughly in its half portion, it is very thorough, and I would say really excellent from Judge Alita Trauger, federal judge. And it came down last week denying state of Tennessee's effort for a summary judgment on the law, and granting to two poor men, I believe they're African Americans, granting them a petition to be a representative of a class. And David Perkey, Governor Haslam's commissioner of safety, fought every step of the way. He must have been on the stand for hours, or being deposed for hours in this case. But he's been told that, well, your system of denying people a driver's license and revoking driver's licenses because those people have been too poor to pay their court fines is tending toward irrational, and is tending toward being unjust and unconstitutional. And the Judge Trauger hasn't gone that far yet, but in a 78-page ruling, which I began reading last night and have been working on this morning to try to get through, is a victory for the poor man, and it's in the same direction that we're working on here at the David Toulis Show. David Toulis here, 92.7 FM. We're arguing that you should love your neighbor and buy local. 800-8949 is the number. 800-8949. Listen, if you've had a traffic encounter and you're being accused, do call me, and let's discuss what happened to you. Just take a few minutes out I know you're busy, but if you can, just give me a quick call at 800-8949, and would like to hear of your experience. Now, the experiences that we'll hear from people like you are no doubt very varied. Some might make my point, others perhaps don't provide the factual wherewithal to make it. And of course, some stories are kind of hard to see where the truth is and what the point is, right? Because our show is about ideal. And so in her ruling, which I'd say is overlong, she goes in far too much detail to get the work done. I could have probably done it in 20 pages, but she took 70 pages to get more or less the same information out there. And it's very long and prolix, which means wordy, a prolix ruling. But in its prolixity, there is a great deal of information for me. The host who in bathroom reading has had open for months Gibson's Suits and Chancery, which I have I'm several hundred pages into that. Well, maybe about 300 pages into that, and I haven't even gotten into the second volume. I do that for bathroom reading because I just like to know, and also just that I'm a kind of a crank. I've been reading a very important book published in Amsterdam in 1975 called Legal Fictions. It's by Pierre Olivier, and it's a highly complex book about legal theory. And what I'm coming to understand is that Tennessee and its judges operate on an important legal fiction. Now, you could say a legal fiction is a lie, and the American legal theorist Lon Fuller, probably chief among them, say that they tend to have a kind of a rigid and righteous indignation at legal fictions. Fuller is a Harvard specialist. He was like an expert and has written several books in the probably 1930s, 40s, 50s, and 60s, so legal books. And one of them was a compilation of essays on legal fictions. And I've got that book. But I'm reading the companion volume right now out of Holland, because the Dutch jurisprudence has taken special interest in this creation of legal fictions. What that is, a legal fiction is when a judge creates a falsehood, and it's a falsehood that is accepted. And the question is, what does it do to change the law? Does it make problem in the way of precedents for other cases downstream? What does a legal fiction do? Where is it false? How is it fictional? How is it fraudulent? Or how is it erroneous? Or how is it unjust? Now, these books tend to not deal as much with justice and what the law says as I think they should, at least the one I'm reading now. But they describe a process, whereas courts and judges act on fictions. It's like a fiction is like an analogy, right? A fiction is like an illustration, and it allows judges to apply laws and facts which otherwise are incompatible, right? To apply a law to a set of facts that the law does not have in view can be done, but you have to create a fiction to do it. And I'm suspecting, this is just a mere suspicion, I'm suspecting that today the Tennessee High Court, especially in a recent one-word unsigned ruling, is engaging itself in a legal fiction. And guess who's hurt by that? People like you, my listener, and also people like Rudy Soto Rodriguez of 7602 Lee Crest Lane. He and his wife Daisy have 2 young sons. I believe they're sons. And he is a working man who's been in the country for 13 years, has pretty good English, as I told him. And he works right now, I think, in the framing field, as a contractor in an apartment complex downtown. And what's interesting about the Trauger ruling is that it shows the problem of a state system which arbitrarily creates this so-called state privilege of driving. State privilege is driving. It's also called transportation. It's also called operating. When you operate or drive a motor vehicle, you are ostensibly and presuppositionally involved in commerce, right? You're involved in transportation. But Rudy Rodriguez is not, and he's being charged with driving without a license. But to say that he's actually driving is a presupposition, right? It is a rebuttable presumption, and what he's going to have to do when he goes to court, depending on how he's treated by his attorney or whether he stands for himself, is to rebut the presupposition or the presumption that he was in fact driving. There is no driving, there is no transportation unless there's a bill of lading. Okay, you got that? You've got to have a bill of lading, an agreement, a proof of a contract, or the contract itself that says that you are carrying somebody or something for hire for a certain amount of money, with the pickup point being A and the delivery point being B. That is called transportation. When there's a bill of lading, a document, a certificate that says that you, the person behind the wheel, or the owner of that car/vehicle, you're involved in business of making a profit, and you're doing it for hire. And Rudy Soto Rodriguez, a carpenter and a man in the building trades, is not doing that, right? So what he has to do is rebut the presumption that he's in fact driving. He has to say, what proof do you have that I'm driving? What proof do you have that I'm actually driving? What does driving mean? Can you define driving? And no, driving is not using a car. No, driving under the Transportation Code, which is Title 55, and also under the U.S. Code 49, driving is the for-profit use of the road subject to regulation. And if it's for profit, it's subject to regulation, period. Okay, you're subject to regulation, period. If you have a bill of lading and you're carrying people or goods for hire under contract or under agreement. Now, Judge Trauger, as I was suggesting a moment ago, is kind of getting half the story right. She's pointing out how essential traveling by car is. Now, she calls it always driving, so we'll just have to forgive her for that. She's saying driving is essential. And in her filing, which runs, I think, 78 pages, she takes judicial notice of the essential nature of the car. If you cannot use your car, you are facing a civil death sentence. And David Perkey, the Commissioner of Safety of a Republican governor, admits that he, under a statute, has deprived more than 140,000 Tennesseans of their driver's licenses. He has revoked their driver's licenses, and there are thousands of them in Chattanooga. Thousands of people in Chattanooga, and you probably know some of them, who don't have a license, who cannot properly, as they say, legally use the public road to get to work, to go to the doctor, to take an old relative to shop. These things are forbidden. They're outlawed. They're made criminal by the enforcement practice of D.A. Neil Pinkston, by the enforcement practice of David Roddy, Chief of Police, and Mayor Andy Burke. Mayor Andy Burke agrees in his enforcement practices to overly enforce the statute against innocent people, such as this Hispanic immigrant, Rudy Soto Rodriguez, and thousands of other people. And the state has deprived them of their licenses by revocation process. And the state has done that illegally and unconstitutionally and abusively. And Judge Trauger, the federal judge in Nashville, in this civil rights action, says that she's taking judicial notice that it is an indisputable and commonly known fact that there is a transportation infrastructure, and that it is essential that that infrastructure be there so that people might make their living. And she says that there is a necessity of using the road. Using the road is a matter of necessity. People have to use the road. She says, in discussing David Perkey's objections, she says that pattern continues for several pages, with Perkey objecting even to such undeniably common sense statements such as, quote, many indigent people who owe court debt and whose licenses have been revoked under statute still need to drive in order to get to work, school, or medical appointments. In other words, he won't agree even to that, though she is giving, in her ruling, she is giving judicial notice that that is in fact the case. She says any factual basis for Perkey's resistance to the plaintiff's position, however, is inconspicuously absent. First, the court judicially notices that the public transportation available in Tennessee is widely insufficient to provide an adequate substitute for access to private motor vehicle transportation. Secondly, the court judicially notices, she says, that the services, businesses, homes, and workplaces throughout Tennessee are so geographically diffuse that navigating life in the state wholly on foot is impracticable for all but a few Tennesseans. Third, the court judicially notices that a number of obstacles prevent non-motorized transportation, such as bicycles, from providing an adequate alternative to driving in Tennessee, including the aforementioned geographically diffuse pattern of development, and 2, the need to travel on interstate and highways, 3, safety concerns associated with using non-motorized travel in areas without paths dedicated to that purpose, and 4, the lack of such dedicated paths on numerous important roads within the state, and 5, the fact that many Tennesseans face physical limitations that would not prevent them from driving, but that would sharply limit their use of a bicycle or other human-powered modes of transportation. So she's saying it's impracticable to say people can walk to work. It's impracticable and unreasonable to say that people can bike to work. And then she's pointing out that there are no bike paths, right? You have to use the interstate to get anywhere. in many cases. And she says that it is beyond dispute that cities and towns and communities of Tennessee are pervasively structured around the use of the automobile. In other words, that's the right to travel. The right to travel is in her case, though she doesn't really quite recognize it as that. She says the centrality of motor vehicle travel is not solely a rural problem. Even the relatively dense city of Nashville, where the court sits, is deeply reliant on motor vehicle transport. If any city in this jurisdiction could be expected to be reasonably navigable without driving, it would be Nashville. And the court takes judicial notice, she says, that to the contrary, Nashville is a city where motor vehicle travel is an essential part of ordinary life. 800-8949, 800-8949, particularly for anyone seeking to build, maintain, or build economic self-sufficiency. There is no reason, however, for the court to engage in the preposterous fiction that the question of whether driving is central to life in Tennessee is shrouded in mystery. This is a state of roads, not footpaths, and those roads, for the most part, are filled with private and commercial vehicles. So notice how a tingle goes up my spine when I read that, because she's making the distinction clear. For a moment there, it glimpses through the distinction between private and commercial vehicles. She does use the word vehicle incorrectly, but private cars and commercial vehicles, that would be the proper distinction. Not bicycles, she says, and public buses. And she says that no testimony is required for the court to understand that driving is an important aspect of daily life because it is how Tennesseans get to work, school. Now, here's the part I like. Here is why you have a right to travel by car, and so do I. You have to get to your school, right? To work, to supermarkets, doctor's offices, hospitals, religious services, job interviews, charitable organizations, polling places, and community activities, among other destinations. Nor is testimony required for the court to know that some parts of Tennessee without public transportation include more than the bottom of the Cumberland River or the top of Mount LeConte. The areas without public transportation or with wholly inadequate public transportation include the homes of many Tennesseans, she says, whose rights and desires to engage in the activities of life are no less than those of Tennesseans in the state's city centers. The parties' stipulations accordingly support a holding that the loss of one's driver's license works a substantial hardship on the former license holder's capacity for self-sufficiency, such that a license revocation would be counterproductive to fostering an indigent debtor's ability to pay his debts. We're talking here about the federal court case that creates a civil death sentence for tens of thousands of Tennesseans and thousands in the Chattanooga area. Civil death sentence. Why? They're too poor to pay a court debt, and David Perkey, the Commissioner of Safety, has revoked their driver's licenses, which everyone believes and everyone insists you have to use the public roads. Well, maybe so, but I'd say the story is better than that. And I want you to know one thing, that Rudy Soto Rodriguez is an innocent man falsely accused. He's falsely accused of a crime.
Traffic, news, and information. Nuga Radio, Digital FM 95.3 HD4 and 92.7 FM. 3, 2,